Okay, I'm going to go over the final exam, how you can prepare for it, and do that pretty quickly here. Just to remind you, this is 25% of your final grade, so it's a pretty big bump, and you can definitely improve your grade if you've been struggling, and obviously you want to do well if you've been doing well so far. There's 3 parts to the exam. It will open on December 14th and it will close on December 18th, so you have a few days to get it done. Part 1 is a general survey. You're going to have some ideas about the whole course. Part 2 will be getting specific about thinking like a judge. So you want to make sure you read that part carefully. And then Part 3, you'll be answering 2 of your submitted questions. And you'll show me that you could do socio-legal analysis, meaning that you'll be able to show me that different people in different groups have different ideas about punishment and rights, and that's based on their power. Now, in Part 1, you want to show me how your ideas have changed, what you thought is different than what you think now. Especially it has to do with what law is and how judges do their job. You'll show me that law is not one thing, that there's different stories about what legality means. You'll show me that judges are not referees. They're not balancing between the legislature and the executive. That's a nice thing for textbooks, but that's not reality. They're not neutral. They're appointed by political parties. They are political. But they don't make their decisions in court about political issues because political issues aren't court issues. They're not legal issues. They're for politics. And so they don't make decisions based on opinion or subjective desire. They're constrained and enabled by law school, other lawyers and judges, and the practice of law or being a professional. And so the main thing to understand here is that different interpretations of legal theories and social relations are not right or wrong. They're based on worldview, they're based on your experience, and that's going to be all within the theory of law. It's not outside of it. So the actual specific way that they go through this is a process called abduction. And what they'll do is they'll take rules from other cases and apply it to the facts that are being presented to them by the prosecutor and the defense, or the defense and the plaintiff. And this really has to go within the system you see on the graphic to the right, where there's 3 levels to this process. When they learn about rules from other cases by reading and by staying, up to date with the laws, they're really worried about the appeals process. So if you take a simple concept like liberty, to you and I, we think, oh, that's freedom. But liberty means something very specific in court cases that go back several hundreds of years. And so if they get the wrong concept of liberty from the wrong case, or they misapply it, then they're going to be overruled in appeal. So appeals are very, very important to judges and how they think about their decisions. They don't want to be appealed if possible. And they're only appealed on mistakes of law, not mistakes of fact. So it's not about whether the prosecution or defense, put in their facts correctly. It's about, did the judge apply the correct rule of law? The next thing that changes their way of thinking is the practice of being a judge. So maybe they learned a certain concept like separation of powers or equal application of the laws when they were when they were freshmen in college. And they read a textbook and it said it's such and such thing, but then they see that you can't really practice that way, that nothing is black and white among human beings, and so you can't just apply the textbook definition to situations because they'll never apply. And so they practice, they apply these theories, they write them out, they have applications to them. And so the rules from other cases also affect the way that they think about things because they're practicing being a judge, they're practicing writing out these rules. The final thing is that they're educated in law school, and law school is, intensely focused on these legal processes and these legal rules. And so you're learning about this every day, and this is the habits that judges develop. And so these ideas aren't defined in a dictionary. They're not defined in just talking to other people. They're defined in hundreds and hundreds and hundreds of legal cases that they read and they analyze. These cases and theories are built over hundreds and sometimes thousands of years. And then facts of the case are usually about procedure and legal rulings, not political opinions. Every once in a while, as you saw in Baker versus Carr, a political issue sneaks into the court case and judges have to decide what are they going to do with that. And that's how this kind of legal process works, is that the facts aren't facts that we think about in like facts versus opinions. These are facts as the defense and the prosecution have agreed they are. And so the judge is trying to decide, how does this fit within the legal process or the procedure? And how does this match up to previous case rulings? And so their conclusions are based on how the case should be resolved based on those rules, and then applying those facts according to the set legal process called the rules of procedure. Now, in your example, you really want to make sure you review the judicial notes, because that's a good way that judges, they take their own notes. And so I gave you an example of an actual case of an actual judge, and that's good practice. You also want to review these 3 cases, because these are the 3 rules that could be applied in this hypothetical case that you're going to have to make a decision about. That's Illinois versus Gates, Brinegar versus United States, and Terry versus Ohio. And in short, the defendant wants his lawyer to file a motion to dismiss to say, get rid of this case because there's not enough evidence. And they're saying that the evidence that the prosecution has put forward should not be included because it's based on an anonymous tip. And so in order to support that, the lawyer is going to call an expert witness to say that this is the wrong test. So imagine they're a professor of criminal justice and they're talking about why this test would be a better test. The 2-prong test is the accurate test, and the totality of the circumstances test should not be applied in this case. Then the defendant also wants an expert witness to say that they were under psychological distress, so that they weren't in the right mind when they were making their decisions, and so they didn't have the intent to commit the crime. And then finally, they want the expert witness to basically argue that the evidence is tainted because the person who supplied it, who turns out to be the anonymous tip, is actually engaged with a drug trafficker, and so you can't really trust the evidence that they put forward. Now, in response, the district attorney, the prosecutor, is going to provide a victim statement that alleges that the defendant and the girlfriend, the anonymous tip, are actually, engaged in this process, and they've harmed the community. And so these are the things that the judge is going to have to balance when they try to decide whether to dismiss the case. The third part is going to be drawn from questions that you've generated. So if you look at these questions here in Table 1 and Table 1.1, these are all things that have come up, and I'd like you to answer 2 of these questions. And, it won't be a big secret. One will come from the left side and one come right. When you answer these questions, the real key here is not to just answer with your opinion. It's to use the language from the assigned readings and make sure that you are applying a socio-legal analysis, so showing me that you can think outside of the judge's mind and try to see how will this actually affect society. And so you're going to show me that you have now let go of the simple idea or the internet idea that sovereignty is a supreme authority, because it's not. That doesn't even mean anything. It's also an ideal that some people have. Wouldn't it be nice if there was a supreme authority sovereign that made all our decisions for us and we didn't have any choice? But that's not reality. That's not what actually happens. What you want to show me is you understand now it's constructed as a concept, right? It's just a word that people use to describe things, and it means different things to different people. And so you should show me that you mean it one way and that other people might mean it another way, and you show me how this is based on your background, on your gender, on your culture, right, and these other constructed identities that we believe in. The other thing you want to show me is that law is more than one thing, and that it's punishment, definitely, right? We have a penal system, we have prisons, we have consequences. Not everybody gets in trouble, obviously. They don't get caught. Not everybody has to go to jail. Some people buy their way out, right? But the law is also this limit on the abuse of power, which we tend to think about as rights, right? And so this is always this balance between the two, between freedom and control, between punishment and liberty, right? And this is both in the courts, and it's seen differently in the courts, right? Those concepts, and it's balanced differently. And then down on the street, right, between everyday people. And there's 3 articles that really help you understand this. It's the Black Lives Matter article, the Fire This Time, it's the DeLand Key of Law article, and it's the article about Foucault when he's having an argument with the Maoists, with the communists, about what popular justice would look like. So the way that ordinary people or everyday people look at the law, right, how what they think about punishment and rights and that balance is different than judges. Now, largely that's because one's trained and the other one's not, and so they've been kind of socialized differently. But they also have different perspectives because they have different related power, right? They have different positions in society. They have different class backgrounds. They're accepted differently, right? So they get to participate in rulemaking. So you want to think about how all of these things inform an analysis, right? So you're analyzing. You're not just saying your opinion, you're looking at the whole picture. And so that's really the main thing for part 3, is to show me that you can now apply this knowledge. And that means you're ready to move on to the next level of classes. So that's all 3 parts. And I wish you all luck, and you'll all do wonderfully.